Well, Donald Trump's even losing with Trump-appointed judges. We've got our ruling from Judge Cullen coming out of Virginia, in which he said that Donald Trump's attempt through the Department of Justice to sue all 12 members of the federal court in Maryland because they don't like what I'll refer to as the Abrego-Garcia local rule established that says nobody can be removed for 48 hours after a writ of habeas corpus petition has been filed. Because Trump doesn't like that, he then sued to try to change the rule. It's the exact opposite of what you are supposed to do in suing a co-equal branch of government. Or as Judge Cullen put it, they've created a constitutional free-for-all. We're not a constitutional free-for-all. We believe in the rule of law here on MeidasTouch and on Legal AF. Let me get to Judge Cullen's 38-page opinion against the Trump administration. Just came out, breaking news. How did we get here? About a month or so ago, the chief judge of Maryland issued a local rule which was consistent with rules adopted by appellate courts, that when writs of habeas corpus petitions are filed with a federal judge, they're so momentous, they're so serious about the life and liberty of a person who's been incarcerated or detained, that he felt he needed to build in watching the Trump administration take these people in the middle of the night and send them out of the country, as in Abrego Garcia, and 200 people sent to the torture chamber of El Salvador's jails. The chief judge in Maryland said, and he sits over Judge Zinnes, dealing with Abrego Garcia's issues, constitutional issues, said, you know what? Why don't we put a pause on this? Here's my new local rule. 48 hours, everybody stands still, nobody gets deported, nobody gets accidentally removed while a writ of habeas corpus petition is assigned to a federal judge, and that federal judge sets procedure related to it. We're watching a version of that now. It's the Abrego Garcia rule, as I call it, and it's being applied to Abrego Garcia, who Judge Zinnes had time because of the 48-hour rule and her prior orders to get the lawyers in front of her and set a briefing schedule while he remains in the United States and hasn't yet been sent to Uganda. So now you've got the framework. So why Judge Cullen? Well, when you sue the entirety of a federal district and every judge in it, they can't hear your case because they all have a conflict. So the Fourth Circuit Court of Appeals chief judge, this is the procedure, who sits over the Maryland federal court, appoints a judge from outside of Maryland, but that is within the Fourth Circuit to hear the case. It landed on the desk of Judge Cullen, who's a Trump-appointed judge from the first term. Similarly, we just saw it with Alina Habba, where all the judges there refused to make her the U.S. attorney for an extended period of time. So it had to be assigned to a judge in Pennsylvania to make the ruling against Alina Habba, finding her unconstitutionally, unlawfully appointed. Same concept. Now let me get to what just happened. You're here on the MeidasTouch Network. You're with us on Legal AF. I'm Michael Popok. And let's take that minute. Here's what the court said, and I'll read to you from. It's always great to start from the end of the order, which is again 39 pages. Here's how Judge Cullen ends it. In their wisdom, the Constitution's framers, this is on page 36, joined three coordinate branches to establish a single sovereign. Three co-equal branches of government make up our constitutional republic. That structure, the judge continues, may occasionally engender clashes between two branches and encroachment by one branch on another's authority. But mediating those disputes must occur in a manner that respects the judiciary's constitutional role, citing Trump versus Casa. See, Donald Trump's making his own case law against him. Trump versus Casa, that's a case involving the birthright citizenship that the Supreme Court decided just about a month or so ago. As Judge Wilkinson aptly noted, he's the leading judge, senior judge in the Fourth Circuit, noted in a case posing a similar, though less direct clash, that was in the Abrego Garcia case, upholding the decision by Judge Zinnes. This is what Judge Wilkinson said that Judge Cullen is repeating. Quote, a reciprocal respect for the roles of the executive and the judiciary may be too much to hope for in this fraught and polarized of times. but it remains the only way that our system of constitutional governance can ever hope to work. Judge Wilkinson is a rock-ribbed Republican, conservative icon. Speaking of Mount Rushmore and who should be on it, if there was a Mount Rushmore for conservative judges, Judge Wilkinson would be on it. That's who wrote that statement about Donald Trump. Much as the executive, Judge Cullen continues, fights the characterization. A lawsuit by the executive branch of government against the judicial branch for the exercise of judicial power is not ordinary. The executive's lawsuit will be dismissed, and its motion for preliminary injunction to block the rule. They're fighting over 2 days because they want to whip these people out of the country and send them to the terror prisons of other countries. This is all we're talking about, 48 hours until a federal judge can get their arms and minds and hands around the case. Here's what the judge says. The executive's lawsuit will be dismissed, its motion for preliminary injunction denied. Whatever the merits of its grievance with the judges of the United States District Court for the District of Maryland, the executive must find a proper way to raise those concerns. Now, what's he talking about? Well, if you're the government and the Department of Justice, and you don't like the local rules established by the chief judge, because that's how this operates. We've got the federal rules of civil procedure and the federal rules of criminal procedure. They're big, thick tomes, electronic now, that are established and adopted by the federal courts and adopted by Congress. That's the rule books. But then local rules, each district, the chief judge, depending upon the peculiarities of that district, can set other rules that have to be complied with. Now, they can't be inconsistent, but they can be in addition to and supplement. It's addition, not subtraction. If you don't like the rule, there is a way to challenge it in the Fourth Circuit, which Judge Cullen reminded. You can go to you will have to go to the Judicial Council of the Fourth Circuit under 28 United States Code Section 2071, who have the power to rescind local rules if it's brought to their attention and good cause is shown. That's what they needed to do. They didn't want to do that. They wanted to try to get the Maryland federal judges who were ruling against them. You know, that's where Judge Reyes sits about the transgender troops and about the DC takeover. That's where Judge Zinnes sits. They've gotten the Trump administration has got a lot of bad rulings from the Maryland federal judges, and for good reason. So can we get rid of the entirety of the federal bench? Let's try it. And Judge Cullen is saying, no, let's not try it. First of all, they have judicial immunity. And it's not, it's a hard thing to argue. They don't just give it out willy-nilly, judicial immunity, but if it's given out, it's absolute. And if all the judges you're accusing them of is doing their job and they have subject matter jurisdiction over a certain matter, which the chief judge did to issue this ruling, you can't sue them. And what did the others do? They were following the 48-hour rule to not allow somebody to be deported with a standing order while they got their case up and running about the writ of habeas corpus. What did they do? So they had subject matter jurisdiction. The chief judge had subject matter jurisdiction, and judicial immunity, which is the primary reason that the Trump just lost this case in the Department of Justice, would protect them from any type of suit like this. Now, Cullen is saying, you don't like the rule, go to the Fourth Circuit Court of Appeals Rules Committee, Judicial Council, and have them change it. Or take an appeal from me. But that is what you're supposed to do. I want to read you a couple of footnotes. One of them I interpreted as a sort of I don't want to say a veiled threat, but a reminder by Judge Cullen of what's at stake here in this case if he were to allow it to proceed, which he, of course, is not, because he commented, I don't want to create a constitutional free-for-all. So here's what he says in the footnotes. You hear me scrolling in the background. In footnote 1, he said, here it is. In footnote 3 or 2. I'll get it right. In footnote 2, see? Live recording, everybody. Indeed, this is Judge Cullen, over the past several months, principal officers of the executive, meaning the Trump administration, and their spokespersons have described federal district judges across the country as Remember, he's a Trumper. He's a Trump-appointed judge. Left-wing, liberal, activists, radical, politically minded, rogue, unhinged, outrageous, overzealous, and unconstitutional, crooked, and worse, Judge Cullen said. Judge Zinnes alone has he left out one, Marxist. I've heard Judge Zinnes be called by the Trump administration Marxist, leftist, radicalist. Although some tension, Judge Cullen wrote, between the coordinate branches of government is a hallmark of our constitutional system, this concerted effort by the executive to smear and impugn individual judges who rule against it is both unprecedented and unfortunate. This is the one where I think it's a little bit of a shot across the bow from this federal judge to the Trump administration, reminding them of what's at stake. He said, if I hadn't dismissed this case, this is in footnote 3 on page 4, then we would have had a lot of activity you may not have wanted. If the case were to survive this motion to dismiss, he wrote in footnote 3, Judge Cullen, the parties, the individual judicial defendants, and principal officers of the executive, that's you, Trump administration, including the Secretary of Homeland Security, the United States Attorney General, would potentially be required to sit for deposition and produce documents, including emails and other internal communications relevant to the issuance of the standing orders and the actual reasons for filing the suit. Do you want that, everybody? Because that's what you're going to get if I hadn't dismissed the suit. These discovery demands, in turn, would almost certainly trigger claims of privilege, executive, judicial, deliberative process, and the like, and invariably compound this constitutional standoff into epic proportions. So don't do it. Appeal me, sure. Go to the Judicial Council of the Fourth Circuit where you should have started. And then he says, and all of this other stuff you're talking about in your case law, like, well, the First Circuit did it a different way. That's because a court in the First Circuit ordered the U.S. attorney to do it a different way. Here, there is a way in the Fourth Circuit, and it's being ignored by the Trump administration. And so what does it mean? This attack and assault on the co-equal branches of government, for now, has been quelled by a federal judge named Cullen, sits in Virginia, about sitting by designation on a matter in Maryland, and the local rule continues. What I call the Abrego-Garcia rule. You file a writ of, if a petition for writ of habeas corpus to stop a process and to have a federal judge determine whether incarceration or detention is proper, whether it's immigration law or criminal law. When that petition gets filed, nobody gets removed, nobody gets deported, nobody gets sent out of the country for 48 hours while a federal judge gets onto the case, gets assigned to the case, calls the parties together in the case, and issues an order in the case. And the fact that Donald Trump is fighting that is depraved. No, I want to send them to El Salvador to be tortured before a federal judge can decide on due process and habeas corpus. No. We're not going to allow the constitutional free-for-all. I'm glad you joined me here on MeidasTouch and Legal AF. I'm Michael Popok. Come over to Legal AF, the YouTube channel, hit the subscribe button there, and come to our new community that we're building on Legal AF Substack. I do 2 or 3 lives a day at the minute about orders just like this one, and pull together 2,000, 3,000 people in a huddle, and we talk it through, and you get the information in real time on Legal AF Substack. Join me there as well. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.